Before we begin, a quick and important disclaimer. The following content is provided strictly for educational and entertainment purposes and does not constitute professional legal, financial, or career advice. The statistics, historical trends, and case studies presented are based on data available as of 2026 and are subject to change. Engaging a divorce attorney involves significant legal and financial implications that vary by jurisdiction. Viewers are strongly encouraged to conduct their own due diligence and consult with a licensed professional in their specific state before making any decisions related to legal representation or career paths in the legal field. Right now in the United States, a marriage ends every 36 seconds. That is nearly 2,400 divorces per day. And behind almost every single one of those filings is a professional whose entire livelihood depends on the dissolution of a domestic contract: the divorce attorney. We are looking at an industry that was valued at $4.35 billion in 2024 and is on a trajectory to hit $6.2 billion by 2035. But here is the part that should make you lean in. While the general public assumes the divorce business is a goldmine of high-conflict drama and endless billable hours, the data shows a massive shift in how money is actually moving through these firms. We are entering an era where AI-assisted document generation and unbundled legal services are cannibalizing traditional hourly billing. Yet the top 10% of practitioners are seeing their income skyrocket to over $250,000 a year. Today, we are opening the books on one of the most misunderstood professions in America. We will analyze the raw data behind the billable hour, the geographic pay gaps that see attorneys in Pennington County, South Dakota, out-earning their peers in New York City, and the brutal reality of the $15,000 to $20,000 average cost for a single case. If you have ever wondered why some lawyers thrive while others burn out, or if you are trying to understand the financial machinery of the American legal system, this deep dive is for you. To understand the divorce attorney profession, we must first look at the sheer scale of the market they inhabit. As of 2025, the refined divorce rate in the United States sits at approximately 14.2 women divorcing per 1,000 married women. While this is a slight decrease from previous years, the total volume of cases remains staggering. With nearly 1 million people finalizing a divorce annually, this creates a massive, consistent demand for legal services, but that demand is not distributed equally. Historically, we see the highest activity in states like Oklahoma, Nevada, and Mississippi, where refined divorce rates can climb as high as 20.7 per 1,000. Conversely, states like Maine and New Jersey maintain much lower rates, around 10 to 11 per 1,000. For an attorney, geography is destiny. You aren't just looking for where people are getting divorced. You are looking for the intersection of high divorce rates and high asset values. The financial barrier to entry for a client is significant, which dictates the attorney's revenue model. The average cost of a divorce in the U.S. currently ranges between $15,000 and $20,000. This isn't just a random number. It is a calculated accumulation of hourly rates, filing fees, and specialized service costs. Hourly rates for divorce attorneys typically span from $150 to $500. However, in major metropolitan hubs or high-conflict scenarios, these figures can easily exceed the $500 mark. For a moderately contested divorce, an attorney might log anywhere from 40 to 100 hours. If you do the math, 100 hours at a $300 hourly rate results in $30,000 in legal fees alone, before you even factor in court filing fees, which range from $150 in Wyoming to $450 in California, or the cost of mediators and parenting coordinators. This leads us to the litigation dominance factor. Despite the rise of mediation and collaborative law, litigation services still dominate the market segment, valued at $1.7 billion in 2024. Why? Because high-conflict cases are where the billable hours live. A case involving child custody disputes can add $5,000 to $20,000 to the total bill, because it necessitates multiple court hearings, evaluations, and sometimes the appointment of a guardian ad litem. From a statistical perspective, the divorce attorney's profit margin is often tied directly to the complexity of the marital estate. Now, let's look at the career trajectory from the perspective of the attorney. In 2026, the average annual pay for a divorce attorney in the U.S. is $115,071. That breaks down to about $55.32 per hour. But average is a dangerous word in this profession. The 25th percentile of earners makes roughly $100,000, while the 75th percentile reaches $132,000. The real outliers are the top earners who can bring home $142,500 or more in standard firms, or upwards of $250,000 if they are handling high-net-worth clients in urban centers. What is fascinating in the 2025 to 2026 data is the emergence of salary anomalies in unexpected locations. While we traditionally think of the District of Columbia, New York, and California as the highest-paying regions, with average salaries of $182,050, $166,110, and $165,590 respectively, recent reports show that cities like Pennington County, South Dakota, are reporting average salaries for divorce attorneys as high as $228,786. This is often driven by a lack of specialized competition in high-growth areas, or a concentration of specific types of high-value litigation. But the profession is facing a technological reckoning. For the first time in history, we are seeing a massive shift toward unbundled legal services. In 2024, LegalZoom's acquisition of Hello Divorce signaled a move toward end-to-end digital filing. By July 2025, AI-assisted interview workflows and automated document generation became standard features for many firms. This allows a client who might have spent $5,000 on basic document preparation to now do it for a fraction of the cost through a digital platform. For the modern attorney, this means the low-hanging fruit of simple paperwork is disappearing. They are being forced to pivot into more complex, high-value advisory roles to maintain their historical revenue levels. Furthermore, we must address the gray divorce trend. Historical trends show that while divorce rates among younger demographics are stabilizing or even falling due to delayed marriage and increased cohabitation, the rate for adults over 50 has doubled since the 1990s. For an attorney, these gray divorces are statistically more lucrative. These cases usually involve long-term asset accumulation, complex retirement accounts, pension divisions, and property portfolios. They require more hours, more expertise, and consequently higher fees. This demographic shift is one of the primary drivers of the projected 3.3% compound annual growth rate for the divorce service market through 2035. In this deep dive, we are going to break down exactly how these professionals structure their firms to survive this $6.2 billion shift. We will look at the cost-to-income ratios, the impact of no-fault divorce laws on billable hours, and how the rise of dual-income households has actually made divorces more affordable for the masses while simultaneously increasing the complexity of the legal split. This isn't just about people breaking up. It is about the complex, data-driven machinery of the American legal economy. By the end of this masterclass, you will understand the divorce attorney profession not through the lens of a TV drama, but through the hard numbers that define it in 2026. To understand the economic engine of a divorce law firm in 2026, we have to look past the mahogany desks and into the cold, hard reality of the billable hour. In the legal world, time is the only inventory, and in 2026, that inventory is more expensive than ever. While elite litigators in high-stakes corporate law have begun pushing rates toward $4,000 per hour, the average family law practitioner operates in a different, yet equally calculated, atmosphere. Imagine a typical professional named Sarah. She is a mid-career divorce attorney in a bustling suburb outside of Chicago. For Sarah, every single day is a race against a metric called the utilization rate. On average, attorneys in the United States have a utilization rate of only 43%. This means that out of an 8-hour workday, Sarah is only actually billing her clients for about 3.4 hours. The rest of her time is swallowed by non-billable but essential tasks: marketing the firm, responding to initial inquiries that may go nowhere, and managing the administrative overhead of her office. Plus one. This creates a massive pressure on the hourly rate. To maintain a profitable practice, Sarah must set her rates not just to cover her time, but to cover the 57% of her day that earns her $0. In 2026, typical hourly rates for divorce attorneys range from $250 to $1,000 depending on the complexity of the case and the region. In a state like Massachusetts, a seasoned attorney might bill between $300 and $850 per hour. Plus one. The first major financial hurdle for any client entering this system is the retainer. Think of the retainer as a security deposit or a down payment on future conflict. In 2026, a standard retainer for a divorce attorney in California or Massachusetts typically ranges from $5,000 to $15,000. This money isn't just a fee. It is placed into a trust account. As Sarah works on the case, drafting a motion, attending a 3-hour deposition, or even spending 15 minutes responding to an urgent email, she bills against that retainer. Here is where the data gets granular. A concept known as the evergreen retainer or retainer replenishment is now standard in 2026. Once the funds in that trust account drop below a certain threshold, often 1/3 of the original amount, the client is required to refresh the retainer. This ensures the attorney is never working on credit. For a highly contested divorce, which can cost between $35,000 and $75,000 in total legal fees, a client might have to refresh that $10,000 retainer 4 or 5 times before the final decree is signed. +1. But why does it cost so much? Let's break down a case study. Imagine a couple, Mark and Elena, who are 2026 professionals with a home, 2 cars, and a shared investment portfolio. Their divorce is moderately contested. The initial filing and response might take 5 to 10 hours of attorney time. The discovery phase, where both sides must legally disclose every bank statement, tax return, and asset, can easily take 20 to 40 hours. Negotiations and temporary orders for support or custody often add another 15 to 30 hours. In this scenario, at a modest rate of $350 per hour, Mark and Elena are looking at $28,000 in legal fees before they even set foot in a courtroom for a trial. This is why the industry is seeing a massive surge in mediation. Mediation costs in 2026 typically range from $420 to $2,000, a fraction of the cost of traditional litigation. However, the paradox of the profession is that while mediation is better for the client's wallet, the high-margin revenue for the firm still lies in the $1.7 billion litigation market. There is also the hidden cost of the support staff. Most firms in 2026 utilize a tiered billing system. While Sarah bills at $400 per hour, her paralegal might bill at $150, and a junior associate might bill at $250. This is designed to maximize the firm's efficiency, but from a statistical standpoint, it also increases the total number of hours billed to a single case. A firm with a high realization rate, the percentage of billed hours that are actually paid by the client, can see significantly higher profit margins than a solo practitioner who struggles with collections. Marketing is another massive, often invisible drain on these funds. In 2026, law firms are increasingly forced to act like tech companies. About 78% of law firms now use paid search marketing, but surprisingly, 82% of them report that the return on investment is underwhelming. To stay competitive, firms are allocating roughly 45% of their marketing budgets to SEO and 30% to pay-per-click advertising. When you realize that 75% of clients visit between 2 and 5 law firm websites before making a phone call, you begin to understand the desperate arms race for digital visibility. +2. This brings us to a critical shift in 2026. The impact of artificial intelligence on the billable hour. Approximately 45% of legal professionals are now using AI daily to reduce costs and increase internal efficiency. AI is being used for drafting social media posts, but more importantly, it is being used to analyze thousands of pages of financial discovery in seconds, a task that used to take a junior associate 20 billable hours. This creates a fascinating statistical tension. As attorneys become more efficient, they have fewer hours to bill. To counteract this, many firms are shifting toward value-based pricing or flat fee models for specific services, rather than relying solely on the traditional clock. But what happens when the assets are not just bank accounts? What happens when an attorney has to divide a cryptocurrency portfolio that has fluctuated 20% in value during the 3 months of the discovery phase? Or what about the rising trend of pet custody disputes, which have no clear legal framework, but can lead to dozens of billable hours in emotional negotiations? As we move forward, the question isn't just how much an attorney makes, but how they survive a market that is simultaneously growing in total value while being disrupted by technology and changing social norms. We have seen the costs, the retainers, and the marketing budgets. But there is a darker side to these statistics, one that involves the psychological toll on the professionals and the high-stakes games played in the courtroom that can double a bill overnight. In the next part, we are going to look at the specific tactics used during the high-conflict discovery phase that turn a $10,000 divorce into a $100,000 war. We will dive into the math of hidden assets and how forensic accountants become the most expensive allies a divorce lawyer can have. You might think you know where the money goes, but when we reveal the true cost of forensic tracking in 2026, you will see exactly why some divorces are worth more than the houses the couples are fighting over. Imagine if you are sitting across from your attorney, and they ask a simple question. Do you know every single place your spouse has moved money in the last 7 years? Most people say yes, but the data tells a different story. In 2026, the discovery phase is no longer just about exchanging bank statements. It has evolved into a high-stakes scavenger hunt for digital and hidden assets. This is the stage where the billable hours for a divorce attorney can move from a steady stream to a flood, and it is largely driven by a single professional, the forensic accountant. In 2026, the forensic litigation support market is valued at a staggering $17.24 billion. For a divorce attorney, bringing in a forensic expert is a strategic calculation. While the attorney manages the legal strategy, the forensic accountant manages the math of suspicion. These professionals typically charge between $300 and $500 per hour, and a standard engagement for a moderately complex case usually results in total fees ranging from $3,000 to $10,000. In high-net-worth scenarios involving multiple businesses or international holdings, those costs can easily double or triple. Plus one. Let's look at a case study involving a character named David. David is a tech executive in Seattle whose marriage is ending in early 2026. He suspects his spouse has been funneling marital funds into a startup venture, or perhaps a separate digital wallet. His attorney initiates the discovery process, which is the formal pretrial procedure where each side must exchange relevant information. When initial disclosures seem incomplete, the attorney triggers three specific, high-cost maneuvers that define the modern divorce economy. First is the lifestyle analysis. This is where the forensic accountant scrutinizes the last 3 to 5 years of bank and credit card statements to compare reported income against actual spending. If David's spouse reports an income of $150,000 but has spending patterns, vacations, luxury goods, or private school tuition consistent with $300,000, the attorney has identified a lifestyle gap. Identifying this gap requires dozens of hours of data entry and cross-referencing, which can add $5,000 to the legal bill before a single motion is filed. Second is the tracing of assets. In 2026, this increasingly involves the digital forensics market, which is projected to reach $15.7 billion this year. Attorneys are no longer just looking at paper trails. They are looking at the blockchain. Cryptocurrency is now treated as community property in states like California, but its volatility makes it a nightmare for valuation. Imagine if David's spouse bought $50,000 worth of Bitcoin in 2023. By 2026, that could be worth $200,000 or $20,000. A digital forensic expert must be hired to trace transfers through multiple wallets and exchanges like Coinbase to ensure the asset isn't hidden offshore. This technical complexity introduces a significant cost. A single crypto tracing report can cost $5,000, but it might uncover $100,000 in marital property. Plus three. Third is the business valuation. If one spouse owns a business, the divorce attorney must determine its fair market value. This is one of the most litigated areas in 2026 because it is subjective. A forensic accountant might use an income approach, looking at future cash flows, or a market approach, comparing it to similar sold businesses. This process is labor-intensive. For an attorney, managing a business valuation often involves 15 to 20 hours of communication with experts, reviewing tax returns, and defending the valuation in depositions. At $400 per hour, the attorney's time alone for this one task hits $8,000. The statistical reality is that discovery is where the attorney-client relationship is most tested. According to historical trends, the discovery phase can account for up to 50% of the total legal fees in a contested divorce. If a spouse is uncooperative, the attorney must file motions to compel or issue subpoenas. Every subpoena sent to a bank or an employer can take 2 hours to draft and process. If there are 10 banks involved, that is $4,000 in fees just to get the documents in the door. This is why we see a growing trend in 2026 toward limited scope representation or unbundled services. For many Americans, the cost of a full-scale forensic search is simply prohibitive. They may choose to hire an attorney only for the high-stakes parts of discovery, while handling the basic document collection themselves. However, for those with high-value estates, the investment in a forensic accountant often yields a high return. Case studies show that forensic experts uncover hidden or undervalued assets in a significant percentage of high-net-worth cases, often finding funds moved into shell companies or deferred compensation plans. But here is the twist. While the technology to find money has improved, so has the technology to hide it. We are seeing a rise in what is called lifestyle dissipation. This is when a spouse strategically spends down marital assets on non-marital expenses, like high-end travel or gifts for others, before the divorce filing. A divorce attorney in 2026 has to be part lawyer, part private investigator, and part data analyst. The psychological toll on the attorney during this phase is immense. They are managing hundreds of thousands of data points, while navigating the emotional volatility of their clients. Statistics show that 75% of clients visit multiple websites before choosing a lawyer, often looking for someone who promises an aggressive approach to discovery. This pressure to be a pit bull drives up conflict, which in turn drives up the billable hours. When you add it all up, the attorney's hourly rate, the forensic accountant's fees, the digital tracing experts, and the court filing costs, it becomes clear why the average contested divorce in 2026 costs more than a new car. But as expensive as discovery is, it pales in comparison to what happens when the case moves from the conference room to the courtroom. In the next part, we are going to look at the math of the trial itself. We will break down why a single day in court can cost $10,000 in legal fees, and why 95% of cases settle before they ever reach a judge. We will reveal the specific pressure points attorneys use to force a settlement at the 11th hour, and the statistical winner's curse that often leaves both parties financially drained regardless of the verdict. You think discovery is expensive? Wait until you see the cost of the final stand. Imagine if you are standing in a hallway made of marble and hushed whispers. Your attorney leans in and tells you that the next 8 hours will cost you exactly what you paid for your first car. This is the reality of the American divorce trial in 2026. While about 95% of divorce cases in the United States are settled out of court, that remaining 5% represents a massive financial engine for the legal profession. For a divorce attorney, the trial is the most labor-intensive, high-risk and high-reward phase of their entire practice. To understand why, we have to look at the math of trial preparation. For every 1 hour an attorney spends in front of a judge, they have typically spent 5 to 10 hours preparing behind the scenes. This preparation includes drafting trial briefs, preparing witness testimony, organizing thousands of pages of exhibits, and conducting mock cross-examinations. If a trial is scheduled to last 3 days, which is common for cases involving complex property division or custody disputes, your attorney might bill 100 hours of preparation time alone. At a 2026 average rate of $350 per hour, that is $35,000 before the judge even says hello. Now let's look at a character named Michael, a business owner in Georgia. Michael's divorce has reached a total impasse over the valuation of his commercial real estate holdings. In 2026, a contested divorce like Michael's can easily exceed $50,000 in total costs. Once the case moves into the courtroom, a new set of fees enters the chat. Court reporter fees for transcripts, $300 to $800 per day. Appearance fees for expert witnesses, $200 to $1,000 per day. Daily attorney trial fees, often a flat daily rate or continued hourly billing that can reach $3,000 to $5,000 per day. In Michael's case, he has to pay his own attorney and his own expert witnesses. But here is the statistical trap. In many jurisdictions, if one spouse is the primary earner, the judge may order them to pay a portion of the other spouse's legal fees as well. This means Michael could be paying $1,000 an hour for 2 separate legal teams to fight each other. This leads us to the psychological and economic phenomenon known as the winner's curse. In auction theory, the winner's curse suggests that the winner often overpays for an item because their bid was based on an overly optimistic valuation. In a 2026 divorce trial, this happens when a spouse spends $100,000 in legal fees to win an extra $80,000 in assets. Statistically, they have won the legal battle but lost $20,000 in net worth. Attorneys call this the cost of principles, but from a data perspective, it is a significant drain on marital wealth. The 95% settlement rate isn't just a coincidence. It is a forced economic outcome. As the trial date approaches, the financial pressure becomes a secondary mediator. Attorneys often use the looming trial costs as a strategic lever. Imagine if your attorney shows you a spreadsheet. On the left is a settlement offer that gives you 45% of the assets. On the right is the projected cost of a 5-day trial with a 50-50 chance of getting 55% of the assets. Once you factor in the $40,000 in additional trial fees, the 45% settlement often looks like the smarter financial move. Historical trends show that the most expensive days in a divorce are not the ones spent fighting, but the ones spent waiting. In 2026, court backlogs in states like California and New York mean that a trial date might be set 12 to 18 months in the future. During that year of waiting, the attorneys are still billing for status conferences, updated discovery, and endless emails. This is why a simple contested divorce in Georgia can range from $15,000 to $30,000. But as soon as it touches a courtroom, those numbers are treated as a floor, not a ceiling. But there is one factor that can blow these statistics out of the water: child custody. The fight moves from bank accounts to human beings. The economic logic often disappears. In 2026, custody evaluations conducted by mental health professionals cost between $2,500 and $10,000. If the case goes to trial, these evaluators bill for their testimony at premium rates. For the attorney, these cases are the most demanding because they require a different skill set: part legal expert, part psychologist. The profession is also seeing a rise in specialized trial tech. In 2026, high-end firms use digital evidence presentation systems and AI-powered jury, or in this case, bench sentiment analysis, to predict how a judge might rule based on past decisions. These tools add another layer of cost, sometimes thousands of dollars in licensing fees passed on to the client. As we look at the wreckage of a trial, the transcripts, the expert reports, and the final decree, a clear picture emerges. The divorce attorney profession in the U.S. is built on the reality that peace is cheaper than justice. The system is designed to make the final stand so expensive that only the most determined or the most wealthy ever actually take it. In the next part, we are going to look at the geography of divorce. We will reveal why being a divorce lawyer in a no-fault state like Nevada is a completely different business model than practicing in a state with complex alimony laws. We will dive into the divorce capital statistics and show you exactly where the most money is being made in the U.S. legal market right now. You think a lawyer in New York makes the most? The data for 2026 has a massive surprise for you. If you were to bet on where the highest-earning divorce attorneys in America are located in 2026, your mind would likely drift toward the skyscrapers of Manhattan or the palm-lined streets of Beverly Hills. Statistically, you would be looking in the wrong direction. While New York and California boast impressive average attorney salaries of $195,000 and $201,000 respectively, the real gold mines are found in places the average person wouldn't expect. Imagine a character named Robert, a senior divorce attorney who recently relocated his practice. In 2026, the data shows that the highest-paying city for this profession isn't a coastal hub. It is Pennington County, South Dakota, where the average annual pay for a divorce attorney has climbed to a staggering $228,786. Close behind are locations like Beverly, Massachusetts, at $224,564, and Glenwood Springs, Colorado, at $220,683. These are not anomalies. They are the result of a precise economic cocktail: a high concentration of wealth mixed with a scarcity of specialized legal experts. To understand this geographic income gap, we have to look at the state-level variables that dictate an attorney's revenue. In the U.S. legal market, there is a concept called positive wage variance. In Pennington County, for example, attorneys earn nearly 99% more than the national average of $115,071. This happens because in these niche markets, attorneys can charge premium metropolitan rates while maintaining the lower overhead costs of a mid-sized city. But geography doesn't just impact what an attorney makes. It dictates the entire legal strategy they must sell to their clients. In 2026, the United States is roughly divided into two legal philosophies: community property states and equitable distribution states. In community property states like California, Texas, and Washington, the law generally mandates a 50-50 split of all assets acquired during the marriage. For an attorney, this means the billable hours are focused on classification, proving whether an asset is separate or community. In equitable distribution states like New York and Florida, the split must be fair, but not necessarily equal. This is a massive revenue driver for attorneys because fairness is subjective. It requires hundreds of billable hours spent arguing over non-monetary contributions, future earning potential, and the standard of living during the marriage. Now let's look at the entry fee for divorce across the country. In 2026, court filing fees alone can act as a barrier to entry or a minor nuisance depending on the zip code. California remains the heavyweight with filing fees ranging from $435 to $450. Florida follows closely at $400. Meanwhile, in states like Mississippi or Wyoming, you can file for as little as $150. These fees might seem small, but they correlate with the overall cost of legal representation in those areas. There is also a significant shift occurring in 2026 regarding how child support is calculated. New legislation in several states has raised the combined monthly net income limits for support worksheets from $12,000 to as high as $50,000. For a divorce attorney, this is a game changer. Previously, when high-earning parents made more than the state's maximum worksheet limit, the court had to estimate the increase, leading to unpredictable results. The new 2026 guidelines provide concrete figures, which actually reduces the amount of time attorneys spend litigating these specific numbers. However, the increased transfer payments often lead to higher stakes in custody battles, which remain the most lucrative part of a family law practice. We are also seeing the rise of divorce tourism. Imagine a scenario where a high-net-worth individual tries to establish residency in a state with more favorable alimony or property laws before filing. In 2026, attorneys are increasingly being hired specifically to handle jurisdictional challenges. This involves analyzing where a case should legally be heard to maximize potential outcomes. A single jurisdictional battle can cost $20,000 in legal fees before the actual divorce even begins. The data for 2026 also highlights a growing divide in how attorneys bill based on their local market. In high-cost urban areas, the evergreen retainer, where the client must constantly top up their account, is now the standard for 85% of firms. In contrast, in mid-range states like Georgia or Texas, we are seeing a 30% increase in flat-fee unbundled services for uncontested cases, typically ranging from $500 to $3,500. This is a survival tactic for local attorneys competing against national online DIY divorce platforms. Historical trends suggest that as the legal market becomes more transparent through AI and online data, the traditional big city lawyer may no longer hold the monopoly on high earnings. As we have seen with the $228,000 average in South Dakota, the most successful divorce attorneys in 2026 are those who find the wealth pockets, where the demand for specialized litigation far outstrips the supply of qualified counsel. But even the most successful attorney in the most expensive city faces a common enemy: the clock. As firms move toward 2027, the very foundation of how they make money, the billable hour, is under threat from a force that doesn't sleep, doesn't charge for lunch, and can draft a motion in 3 seconds. In the next part, we are going to look at the automation takeover. We will dive into the specific AI tools that are currently stripping 30 to 50% of the billable tasks away from junior associates. We will reveal the hidden efficiency gap and show you how some firms are using technology to double their profits while their competitors are going out of business. You think your lawyer is typing those documents by hand? The 2026 data says otherwise, and the reality might change how you view your next legal bill. Imagine a junior associate named Alex working at a top-tier family law firm in 2026. 2 years ago, Alex would spend his entire Monday manually reviewing 500 pages of bank statements and credit card bills to build a marital balance sheet. Today, he uploads those documents into a secure, matter-aware AI platform like Archie AI or CoCounsel. In exactly 12 minutes, the system categorizes every transaction, flags recurring payments to unknown entities, and generates a first-pass asset list. Alex's firm used to bill the client for 15 hours of his time for this task. Now it takes him less than an hour of human oversight. This is the efficiency paradox of the 2026 divorce attorney profession. While AI is compressing 10 to 20 hours of work into mere minutes, the industry is locked in a fierce battle over who gets to keep the savings. The data for 2026 shows a seismic shift in adoption. Individual AI usage among legal professionals has more than doubled in just 1 year, jumping from 31% in 2025 to a staggering 69% today. Nearly 30% of attorneys now use generative AI every single day for tasks like drafting correspondence, summarizing depositions, and brainstorming legal arguments. For a divorce attorney, this isn't just a convenience. It is a fundamental restructuring of their profit margins. Plus one, early adopters of these tools are currently experiencing a lucrative window of opportunity. If a firm can use AI to drop a task from 10 hours to 6 hours while maintaining their traditional hourly pricing, their internal profitability actually widens. However, this window is closing fast as 2026 clients, particularly those in corporate or high-net-worth sectors, start demanding that firms pass those AI-enabled savings back to them. This tension is forcing a split in the profession. We are seeing a move toward flat fee or hybrid pricing for routine, repeatable tasks. In 2026, Services that used to be a bread-and-butter source of billable hours are now being offered as fixed-price packages. Uncontested divorces, simple property settlement agreements, initial document preparation and filing, standardized child support worksheets. For these tasks, attorneys are increasingly acting as editors rather than authors. They use AI to generate a high-quality first draft, then spend their time on the high-value human work, strategy, negotiation, and emotional counseling. But for complex, high-uncertainty litigation, the kind involving hidden offshore accounts or heated custody battles, the billable hour remains king. Why? Because the scope of conflict is unpredictable, and AI cannot yet navigate the asymmetric risks of a trial. +1. However, there is a massive legal and ethical trap waiting for both attorneys and their clients in 2026. A landmark federal court decision in February 2026, United States v. Hepner, sent shockwaves through the industry. The court ruled that materials a defendant created using public AI chatbots, like the free versions of ChatGPT or Gemini, are not protected by attorney-client privilege. Imagine if a client named Sarah uses a public AI to vent or organize her thoughts before meeting her lawyer. She types, "How can I address my ex's substance use issues if they happened 2 years ago?" Because Sarah used a public tool without her lawyer's direction, the opposing side's attorney can now subpoena those logs. In 2026, everything you type into a non-secure AI is a potential piece of evidence. This is why 42% of law firms have pivoted to legal-specific, enterprise-grade AI tools that guarantee data privacy and privilege-safe environments. +1. The financial impact of this technology is even hitting the bottom line of the staff. In 2025 alone, law firms grew their lawyer headcount by nearly 3%, but the way those lawyers spend their time has changed. Instead of spending years paying their dues on document review, associates are expected to lead trials and handle complex negotiations much earlier in their careers, sometimes in year 10 instead of year 20. +1. But as firms become hyper-efficient, a new type of cost is rising: digital discovery of the digital life. In 2026, a divorce isn't just about bank accounts. It's about untangling smart home data, GPS history on smartwatches, and even Alexa recordings. Every single device in a modern home is a witness, and the cost to analyze this data is becoming one of the most significant line items on a legal bill. We have seen how AI is hollowing out the middle of the legal profession, turning standard paperwork into a commodity. But what happens when the data doesn't just show where the money is, but actually predicts who will win the children? In the next part, we are going to look at the psychological pricing of custody. We will dive into the data behind custody evaluators and guardians ad litem, the third-party professionals whose neutral opinions can cost $10,000 and decide the fate of a family. We will reveal the statistical success rates of different parenting plans and show you why, in 2026, your child's schedule is the most expensive document your attorney will ever draft. You might think you can't put a price on family, but the legal system has a very specific number in mind. When we look at the balance sheet of a divorce law firm in 2026, the section labeled custody litigation isn't just a category. It is often the primary revenue driver for mid-sized firms. While asset division is about math, custody is about time and the subjective interpretation of the best interests of the child. In the American legal system, this subjectivity creates an enormous vacuum for billable hours. Statistics from 2025 and early 2026 indicate that cases involving high-conflict custody disputes can be 400% more expensive than those that focus solely on property. Imagine a character named Jennifer, a project manager in Charlotte, North Carolina. Jennifer and her spouse are separating, and both want primary physical custody of their 2 children. In 2026, the standard for most states has shifted toward a presumption of 50-50 joint physical custody, but the path to reaching that schedule is paved with expensive experts. For Jennifer's attorney, the first move isn't a courtroom argument. It is the appointment of a custody evaluator. A custody evaluator is typically a licensed psychologist or social worker. In 2026, the average cost for a full custody evaluation in the United States ranges from $5,000 to $15,000. This fee is often split between the parties, but the legal work surrounding it is not. Jennifer's attorney must spend hours preparing Jennifer for interviews, reviewing the evaluator's 50-page report, and potentially deposing the evaluator to challenge their findings. At an hourly rate of $350, the legal fees just to manage the expert can easily reach $7,000. Then there is the guardian ad litem or GAL, In many states, a JL is a third-party attorney appointed by the court specifically to represent the children's interests. They are the eyes and ears of the judge. Unlike a standard attorney, a JL has the power to visit homes, interview teachers, and review medical records without the parents' consent. In 2026, a GAL's hourly rate typically mirrors that of a standard divorce attorney, ranging from $250 to $450. If a JL spends 20 hours investigating a family, that is another $6,000 to $9,000 added to the total cost of the divorce. Historical trends show that the mere presence of a JL or a custody evaluator increases the likelihood of a settlement, but it does so at a massive financial cost. Statistics suggest that 80% of custody cases settle once a formal evaluation report is released, primarily because the parties can no longer afford to fight the expert's recommendation in court. For the divorce attorney, this is a calculated phase of the litigation cycle where the goal is to use high-cost discovery to force a rational economic decision. Let's look at the parenting plan itself, the document that specifies exactly where the child sleeps every night of the year. In 2026, these are no longer simple 3-page agreements. Modern parenting plans now include clauses for everything from social media usage and digital privacy to the right of first refusal and specific extracurricular expense splits. A comprehensive parenting plan can run 20 to 40 pages long. For an attorney, drafting, revising, and negotiating this document often takes 15 to 25 billable hours. If Jennifer and her spouse argue over whether the children should be allowed to use specific AI-driven educational apps, or who pays for a $3,000 per year competitive soccer league, the meter continues to run. One of the most significant shifts we are seeing in 2026 is the impact of parenting coordinators. These are professionals hired to resolve day-to-day disputes without going back to court. While they are intended to save money in the long run, their initial retainers are often $2,500 to $5,000. In high-conflict cases, a parenting coordinator might be called weekly to decide which parent gets the child for a surprise school holiday, or who is responsible for a missed dental appointment. Each of these calls involves a bill, and each bill is a data point in the total economic impact of the divorce attorney profession. The data also reveals a stark reality regarding the gender pay gap in custody outcomes. While 50-50 custody is the goal for many, the financial burden of child support remains a point of heavy litigation. In 2026, the combined income of parents is the primary factor, but attorneys often spend 10 to 15 hours litigating what constitutes income. Does it include restricted stock units? Does it include the perks of a business owner's company car or cell phone plan? In a 2025 case study from Texas, an attorney spent 40 hours of discovery just to prove that a spouse's corporate expense account was actually disguised income, which ultimately shifted the child support obligation by $800 a month. The cost of that 40-hour investigation was $14,000. It would take nearly 18 months for the client to break even on that legal investment. This is the psychological trap of the profession. Clients often view custody through the lens of moral victory, while the system views it through the lens of billable units and administrative guidelines. Attorneys in 2026 are increasingly being trained into escalation billing, where they proactively advise clients on the statistical likelihood of their desired outcome to prevent them from spending $50,000 on a fight they are statistically likely to lose. However, even when custody is settled, the financial machinery doesn't stop. We have analyzed the experts, the evaluators, and the drafting of the plans. But there is another layer of the divorce attorney's income that remains hidden from most public view: the post-judgment market. This is the world of modifications and contempt filings. As we move into 2027, the data suggests that a staggering 30% of all family law cases are not new divorces, but former couples returning to court because one party didn't follow the 40-page plan Jennifer's lawyer drafted. This recurrent revenue model is what keeps many law firms stable during economic downturns. In the next part, we are going to look at the dark side of the retainer. We will dive into the ethics of billing and the churning of files. We will reveal the specific tactics some firms use to keep a case active just long enough to exhaust a retainer, and why the 2026 American Bar Association is seeing a record number of complaints regarding over-lawyering. You think your lawyer is working late to help you? We'll look at the data that suggests they might just be meeting a monthly billable quota. To understand the structural pressures of a law firm in 2026, you have to look at the math of the billable quota. In many mid to large-scale family law firms, An associate attorney is expected to bill between 1,700 and 2,000 hours per year. On the surface, that sounds like a standard 40-hour work week, but when you factor in the low utilization rates we discussed earlier, the time spent on administrative tasks, training, and marketing, an attorney often has to be at their desk for 60 to 70 hours a week just to hit that 1,800-hour mark. Imagine a character named Christopher, a third-year associate in a high-volume firm in Phoenix, Arizona. Christopher is under immense pressure to meet his monthly billing target of 150 hours. If it is the 25th of the month and he is only at 120 hours, he faces a professional deficit that can impact his year-end bonus or even his job security. In this environment, the temptation for over-lawyering becomes a systemic risk. Over-lawyering isn't necessarily about charging for work that wasn't done. It is about choosing the most time-intensive path for every legal task. Instead of a 5-minute phone call to resolve a minor scheduling conflict with opposing counsel, an attorney might spend 45 minutes drafting a formal multi-paragraph email and CCing 3 different people. Instead of agreeing to a standard protective order, they might spend 3 hours customizing it to the specific needs of the case. Historically, these micro-decisions add up. A 2025 study on legal billing ethics found that clients often see their bills inflated not by major fraud, but by incremental padding. The extra 6 minutes here and 12 minutes there that magically appear on every single line item. In 2026, the American Bar Association and state-level disciplinary boards are seeing a record influx of complaints regarding these practices. Statistics show that nearly 20% of all disciplinary grievances against attorneys involve fees and billing disputes. One specific tactic being scrutinized is the minimum increment rule. Most firms bill in 0.1-hour increments, meaning 6 minutes. If Christopher spends 30 seconds reading a 1-sentence email from his client, he bills 6 minutes. If he reads 10 such emails throughout the day, he has billed a full hour for what was actually 5 minutes of work. At a rate of $350 per hour, the client has just paid $350 for less than 10 minutes of attention. Let's look at a case study of discovery churning. Imagine a spouse who is being difficult about providing tax returns. A streamlined attorney might file a simple motion to compel. However, a firm focused on meeting quotas might first send 3 separate good faith letters, draft a sprawling set of redundant interrogatories, and schedule a 2-hour meet and confer session before finally filing the motion. This process can generate 15 to 20 billable hours for a task that could have been initiated in 2. For the client, this is sold as being aggressive or thorough, but the data suggests it is often just an exercise in exhausting the retainer. The retainer burn is a specific phenomenon where a firm high-loads the beginning of a case with intensive, sometimes unnecessary, research or administrative setup. By the time the case reaches the critical negotiation phase, the initial $10,000 retainer has been depleted. The client is then hit with a request for a second, often larger, retainer just when they feel they are too far in to switch lawyers. In 2026, historical trends show that the mid-case retainer refresh is the #1 cause of client-attorney relationship breakdowns. Furthermore, we are seeing the rise of interoffice conferencing as a major billable category. If Christopher spends 30 minutes talking to a senior partner about your case, and both of them bill for that time, you are paying $700 to $900 for a single internal conversation. While collaboration is necessary, the 2026 Legal Trends report notes that clients are increasingly pushing back on being billed for a firm's internal training or redundant communication. There is also the double billing trap. Imagine if Christopher is at the courthouse waiting for your hearing to start. While he sits there for 2 hours, he uses his laptop to draft a motion for another client. In the traditional pre-digital era, some attorneys would attempt to bill both clients for those 2 hours, one for the waiting time and one for the drafting time. In 2026, sophisticated billing software and court-mandated audits have made this much harder to hide. But the block billing method, where an attorney groups multiple tasks into one large time entry like work on file, 4.5 hours, remains a common way to obscure exactly how time was spent. To combat this, 2026 has seen a 40% increase in the use of third-party bill auditors. High-net-worth clients and insurance companies now hire specialists whose entire job is to use AI to scan legal bills for red flag patterns, such as excessive time for simple tasks or vague descriptions. These auditors have found that, on average, they can reduce a contested legal bill by 10 to 15% simply by enforcing strict billing guidelines. But why does this happen? We have to look at the burnout data. The divorce attorney profession has one of the highest rates of chronic stress and substance abuse, in the American workforce. A 2025 survey found that 35% of family law practitioners report high levels of psychological distress. When an attorney is burnt out, their efficiency drops. Tasks that should take an hour take 3. The client isn't just paying for the lawyer's expertise, they are often paying for the lawyer's exhaustion. This brings us to a critical realization about the 2026 legal market. The most expensive lawyer isn't always the one with the highest hourly rate. It is often the one with the least efficient firm structure. As we look at these statistics, it becomes clear that the billable hour is a metric that inherently rewards slow work. This is the fundamental conflict of interest at the heart of the profession. As we move into the final chapters of this masterclass, the focus shifts from the internal mechanics of the firm to the external impact on the client's life. We have seen how the money is spent and how the hours are billed. But what is the ROI of a divorce? In the next part, we are going to look at the wealth destruction statistics. We will dive into the data on how much marital equity is actually lost to the legal system during a contested divorce, and the post-divorce poverty, trends that affect men and women differently in 2026. We will reveal the settlement versus trial math that shows exactly why the only people who truly win in a 5-year legal battle are the ones wearing the suits. You might think you're fighting for your fair share, but the data shows that by the time it's over, the share itself might have disappeared. Imagine if you spent 20 years building a $1 million nest egg, only to watch $200,000 of it vanish before you even sign the final papers. This isn't just a pessimistic scenario. In 2026, it is a statistical probability for high-conflict cases. While we have focused on how attorneys bill, we now have to look at the other side of the ledger, the actual destruction of marital wealth. In the United States, a contested divorce involving significant assets can lead to a 10 to 20% reduction in the total value of the marital estate, due to legal fees, expert costs, and administrative friction alone. For a character named David, a 52-year-old manager in New Jersey, the math of his gray divorce is brutal. In 2026, adults over 50 account for 36% of all U.S. divorces, a rate that has doubled since the 1990s. David and his spouse have $800,000 in a 401k and $400,000 in home equity. By the time they hire opposing attorneys, forensic accountants to value David's stock options, and pension specialists to draft the Qualified Domestic Relations Orders, QDROs, they have spent $75,000 in combined legal fees. But the destruction of wealth goes deeper than just the checks written to lawyers. We have to address the standard of living gap. According to 2026 data, women over the age of 50 experience a staggering 45% decline in their standard of living following a divorce. Men in the same age bracket fare better but still see a 21% drop. Why the disparity? It is the intersection of the gender pay gap and the cost of two households. In 2026, the median cost to set up a new independent household, including security deposits, new furniture, and separate utilities, is approximately $12,000. When you divide one income-producing unit into two, the efficiency of scale is lost forever. Historical trends show that wealth destruction is most aggressive in the division of the marital home. In 70% of 2026 divorces, the couple must decide whether to sell the house or have one party buy out the other. If they sell, they lose 5 to 6% in realtor commissions and another 2 to 3% in closing costs and moving fees. On a $500,000 home, that is $40,000 of equity gone in an afternoon. If one party buys out the other, they often have to refinance at 2026 interest rates, which can increase their monthly housing costs by 30 to 50% compared to their original joint mortgage. Then there is the tax trap. In 2026, attorneys must navigate complex rules regarding the transfer of assets. While most transfers between spouses during a divorce are tax-free under Internal Revenue Code Section 1041, the future tax liability is often ignored in the heat of battle. If David keeps the $400,000 brokerage account filled with highly appreciated tech stocks, and his spouse keeps $400,000 in cash, David has actually lost wealth. When he eventually sells those stocks, he will owe capital gains tax, whereas the cash-heavy spouse has no such liability. A savvy divorce attorney will bill 5 hours to run these tax projections, but that $1,750 bill could save David $60,000 in future taxes. We also see a rising trend in 2026 called opportunity cost poverty. This is the wealth lost because the parties were too distracted by litigation to manage their investments or careers. A 2025 study found that individuals undergoing a contested divorce see a 15% drop in workplace productivity and are 20% less likely to receive a promotion in the 2 years following the filing. For an attorney, these are the invisible costs they must manage when advising a client to settle. Let's look at the alimony impact. In 2026, spousal support remains one of the most litigated and expensive areas of family law. While men are still the primary payers and women the primary recipients in the majority of cases, the gap is narrowing. The cost to litigate a lifetime alimony award can reach $100,000 because it requires vocational experts to testify about a spouse's earning capacity. If a vocational expert costs $5,000 and the attorney spends 20 hours preparing the cross-examination, the client has spent $12,000 just to argue over a monthly payment that might only be $2,000. The data for 2026 suggests that wealth recovery takes an average of 5 to 10 years for most divorcees. Households typically fall from the 57th percentile of income to the 36th percentile immediately after the split. Even with increased work hours, mothers working 8% more and fathers 16% more post-divorce, they only recover about half of that lost income over the next decade. This leads to a final sobering statistic: the rise of pro se or self-represented litigants. Because the professional cost of a divorce attorney has become so high relative to marital wealth, 72% of family law cases in 2026 involve at least one party representing themselves. This isn't because they want to. It's because they have reached the wealth exhaustion point. They simply have no more equity left to trade for legal hours. As we reach the end of this deep dive into wealth destruction, we have to ask, if the system is this expensive and this destructive, how do the professionals at the top justify the cost? What are the elite 1% of divorce attorneys doing differently in 2026 to protect their clients from this total financial collapse? In our final part, we are going to look at the future of the profession. We will reveal the concierge law model and the collaborative divorce revolution that is attempting to save the American family from the $6.2 billion litigation machine. We will summarize the key data points you need to know to navigate this system without losing your life savings. We've seen the destruction. Now it's time to see the path to financial survival. We are standing at the edge of a fundamental transformation in the American legal landscape. By 2026, the traditional scorched earth litigation model is no longer the only way for a divorce attorney to build a sustainable practice. In fact, the most successful firms in the country are pivoting toward a model that prioritizes the preservation of the marital estate rather than its consumption through billable hours. This shift is driven by a new generation of clients who are more data-informed and less willing to trade their children's college funds for a courtroom victory. To understand where the profession is headed, we have to look at the rise of collaborative divorce. In a collaborative model, both parties and their attorneys sign a binding agreement that they will not go to court. If the process breaks down and they decide to litigate, both attorneys must withdraw from the case, and the clients must start over with new representation. This creates a powerful economic incentive for everyone at the table to find a solution. Statistics from 2025 show that collaborative cases are finalized 25 to 40% faster than traditional litigated cases, and often result in a 30% reduction in total legal fees. Imagine a character named Sarah, an attorney in Austin, Texas. Sarah has transformed her firm into a concierge law practice. Instead of charging a flat hourly rate for everything, she offers subscription-based or phase-based pricing. For a fixed fee of $15,000, Sarah handles everything from the initial filing through the final mediation, including the use of an in-house financial neutral. This model removes the fear of the surprise bill and aligns Sarah's interests with the client's goal: a swift, fair resolution. In 2026, firms using this value-based pricing model report a 20% higher client satisfaction rate and a 15% increase in referral business compared to traditional hourly firms. Another major trend in 2026 is the multidisciplinary team, or MDT approach. High-end divorce attorneys are no longer solo actors. They are the quarterbacks of a team that includes a certified divorce financial analyst, CDFA, a mental health professional acting as a divorce coach, and a child specialist. While this sounds more expensive, the data suggests otherwise. Because a CDFA can analyze a tax return or a pension plan in half the time it takes a lawyer, the total cost to the client often decreases. In 2026, the use of financial neutrals in divorce cases has grown by 55%, as attorneys realize that outsourcing specialized math actually makes their own practice more efficient and less prone to malpractice claims. Let's look at the mediation first mandate. Several states in 2026 have introduced legislation requiring at least 8 hours of good faith mediation before a trial date can even be requested. This has birthed a new specialization within the profession: the mediation consultant. This is an attorney who doesn't represent you in court but works behind the scenes to prepare you for the mediation process, helping you draft your best and final offers based on historical settlement trends in your specific county. Case studies from Florida and Colorado indicate that this consultative law model allows clients to retain professional guidance for $2,000 to $5,000, rather than the $20,000 required for full representation. We must also address the digital courtroom evolution. By mid-2026, over 60% of initial divorce hearings and status conferences in the United States are conducted via secure video conferencing. For the divorce attorney, this has eliminated thousands of travel hours that used to be billed to the client. A lawyer in Los Angeles no longer has to charge $400 an hour to sit in traffic on the 405. They can handle 3 different hearings in 3 different counties from their office in a single morning. This digital shift has lowered the administrative floor of legal fees, making professional representation accessible to a slightly broader demographic. However, the elite 1% of the profession is moving toward private judging. In 2026, high net worth couples are increasingly opting out of the public court system entirely. They hire a retired judge to act as a private arbitrator, while the couple must pay the judge's hourly rate, often $500 to $800. They gain total privacy and a guaranteed schedule. For a divorce attorney handling a celebrity or a high-profile executive, the private judging model is the ultimate way to protect a client's reputation and prevent the leakage of sensitive financial data into the public record. As we summarize the data from this deep dive, the path to survival in the 2026 divorce economy becomes clear. The profession is splitting into 3 distinct tiers. The automation tier: high-volume, low-cost firms using AI to handle uncontested and simple cases for a flat fee of $1,500 to $3,000. The collaborative tier: mid-range firms focused on mediation, MDT support, and wealth preservation, with total costs ranging from $10,000 to $25,000. The litigation tier: elite, high-conflict firms handling the most complex 5% of cases, where fees regularly exceed $100,000 but involve massive asset protection. The historical trends we have analyzed show that while the divorce rate may fluctuate, the complexity of the American household continues to rise. From cryptocurrency and digital footprints to gray divorce and complex support worksheets, the need for professional legal navigation is not going away. But the way those professionals are paid, and the tools they use to justify their fees, are changing forever. We have explored the billable hour, the hidden costs of discovery, the psychological toll of custody, and the wealth-destroying power of the trial. We have seen how geography and technology create massive disparities in what an attorney earns and what a client pays. The divorce attorney profession in 2026 is no longer just about winning a case. It is about managing a $6.2 billion economy of domestic dissolution. But as one door closes on the era of traditional litigation, a new door is opening on the era of preventative law. We are seeing a 25% increase in the drafting of postnuptial agreements, contracts signed during a healthy marriage to predetermine asset division if things ever go south. The divorce attorney of the future may find their most lucrative work is not in breaking families apart, but in helping them plan for every potential outcome long before a conflict ever begins. This concludes our deep dive masterclass on the statistical reality of the divorce attorney profession. You now have the data to look past the drama and understand the true economic machinery of the U.S. legal system. But the legal world never stops evolving, and the intersection of family law and artificial intelligence is about to take another radical turn. Stay tuned as we prepare to analyze the upcoming 2027 legal tech revolution and the specific AI agents that are being designed to replace human mediators entirely. The future of your family's financial security might soon be decided not by a judge, but by an algorithm.